So with that, Chris, if you're ready, or Gretchen, I'll have you start us off.
Oh, is it? Where's the remote at?
Hi, this is Gretchen. Can you hear me okay?
I can hear you.
Oh, wonderful. Well, I can see that Chris is still on mute. So Chris, be sure to unmute yourself. But, you know, over the past 2 days, it's been great chatting with you all, but I know there's been some really specific questions that have arisen around delivery of distance learning and issues related to the special education student population. And Chris is our expert in all things special ed, and I will give the disclaimer before he even begins talking. And really, I think he was more prepared to answer questions you all might have. But one thing I will say is that this is really uncharted territory. So I'm giving Chris a little bit of a break, that if you guys have questions, some of these are things that we need to take back and really research, because it's new for us as well.
Yeah, I certainly am open to taking questions. Can everyone hear me? Fine?
Yes, we can hear you.
Okay. I could give just a brief background. We did get, I think people probably are familiar with March 17th CDE guidance. It was not everything we had hoped for, but it was something. Mainly for special education, it kind of reiterated the some of the information from Governor Newsom's executive order, and also from some guidance we have received from the U.S. Department of Education initially. And their initial guidance, mostly what everyone is worried about in special education are the timelines. And we did get some legislation, SB 117, that told timelines only relating to California law, which were really very, very narrow. Most of the timelines originate in special education from federal law. So SB 117 told some timelines just relating to some very narrow issues in California law, mostly relating to how long a district has to develop an assessment plan once a parent requests one, which is typically 15 days, and those timelines are told. There are some others about requests for records and such. Probably the more helpful guidance, I think, came from the Office for Civil Rights. Provided some guidance about, although not a formal waiver, that for assessments, that if assessments required face-to-face, which most do, not all, face-to-face meeting, or required observation, which is another important part of an assessment, that those would be delayed during school closures. So they gave us a little bit of help there on the assessment process. That's the brief broad overview, but like we said, if anyone has questions, I'm open to trying to answer them.
Chris, this is Gretchen again. One of the questions that came up yesterday was record keeping recommendations during regarding special education students and delivery of services.
Yeah, and that's, we have talked about that, and I think districts are doing this differently. I think some don't want to track minutes. You don't have to track minutes for purposes of apportionment, and that's been made clear. But they want you, at least in California, they want you to track attendance for purposes of compulsory education. As far as special education minutes, I'm of the opinion that even there's no specific guidance saying you have to or you don't have to, I would track them, because what we are doing is what we'll receive once schools reopen, we're going to get a lot of claims for compensatory education and services. And we will likely argue that even if all of the minutes were not provided, because that's been made difficult via distance learning, that we still don't owe compensatory education. But at some point, we're probably going to have to show not only how often we met with students, communicated with students via distance learning, but how many minutes I think will likely come up in due process hearings when parents challenge or request compensatory services. So, so my thought is to go ahead and track the minutes. We'll make the argument that it doesn't matter. If districts are able to, I'm kind of going with if they have services in the IEP, a lot of times it'll be something like 2 times a week, 30 minutes each of speech. I've said if you can, try to at least match the frequency, so meet 2 times a week if you can. A lot of times the population they're serving would not be able to really benefit from 30 minutes over through video, but if they can, then they could go ahead and try to provide the full 30 minutes. And speech is one of those that already has been provided online, so that's one of the ones that lends itself a little more to providing via video conferencing. Some of the others don't. Occupational therapy can be more difficult, and sometimes some of these kids have a one-to-one aid. That's obviously not something that you are going to be able to provide those minutes via distance learning. So it's really not a one-size-fits-all, but to answer the question, I would recommend tracking the minutes just in case we need them later.
We have a question in the chat from Mike. Will we be required to track attendance when we open for distance learning? How would that work?
Currently, you're not required to track attendance for purposes of proving that you've provided the instructional minutes. I don't know if that will change. It doesn't appear from the executive order that will change when districts, some of which have already done this, started teaching through distance learning. So I think we would have to, we would keep an eye on either executive orders from Gavin Newsom unless some legislation comes out. But the current executive order continues in place that does not require tracking of minutes for purposes of apportionment.
Great. Other questions? Remember, you're on mute, so just click that little microphone to get yourself off mute if you have a question, or type it in the chat box.
This is Mike again.
Hi, Mike.
Thank you for being here. Since we're still under the executive order, are we still under the order that special ed is in a suspended period, like they talked about last Friday?
The way, and the special or the executive order was clear that it did not waive any federal requirements under the IDA, any special education requirements. If you look at the U.S. Department of Education, which they're getting some pushback from parents, attorneys groups on this, they were the ones that issued guidance saying if a district is not providing any services to general education students through distance learning, they do not have to provide anything to special education students. And we've already seen parents groups have started lobbying for them to clarify that, for them to pull that back. But that's the current guidance from the U.S. Department of Education. So if you're providing no services to gen ed, you don't have to provide anything. It certainly made that become a more attractive option, because there are a lot of complications once you do provide some services to general education students. Now you do have to provide services to students with disabilities, and so a lot of our clients are in that category. I think the easy category is if you're not providing anything, then currently that's the clearest the clearest guidance we have. You don't have to provide anything for special education students, but if you're providing something, then we have to get into how do we start to deliver the services in a student's IEP through alternative delivery models and such. Did that answer your question, or?
Yes, I guess I'm just trying to think about our, our SDC kids that are, I mean, how do we do that when they can't even sit in front of a computer for 5 minutes or anything,
And that, yeah, that's a good example. That one that I used right off the bat when this came up is that, especially our moderate to severe population, video conference is not a real viable option for those kids. So, so there may be efforts to do that differently. Well, I guess going back, there is this whole equal access, which some I think interpreted as if you provide video classes to general ed students, you have to provide video classes to everyone. And I don't think that's the case. So I think you still, with students with disabilities, you still have to look at how they would best receive the services. And if it's not effective or beneficial in any way, I don't think there's any requirement or any reason to just try to get online with those students for a certain period of time. So what we've told in cases like that, we've had case carriers look at their students on their caseload and decide what is the best way with all the tools that you have, and different districts have different tools. What is the best way for you to communicate and educate to the extent possible the students on your caseload? And we've seen plans that all look very different. So I don't think you're right on something like that. Mild or moderate severe students with disabilities, if video's not going to work for them, then they should just look at something else. And in the end, none of this will be perfect, because none of this was the preferred method for delivering services to students with IEPs. So I think we're going to be judged on more of a reasonableness standard. You did what you can. There's language in some of the executive order. There's language in the U.S. Department of Ed's guidance that talk about to the maximum extent possible, or to the extent practicable, things like that. Those are the phrases that we're going to be relying on later on when we face challenges. We did the best we could with the tools we had, and then we'll just have to see how that plays out.
Thank you.
This is Gretchen. I want to follow up on something Chris said and just emphasize it, and it also came up on the chat room while we've been talking, amongst other questions. The CDE guidelines or guidance that came out a couple days ago reiterated that equal access does not mean equal modes and equal delivery to all students, whether we're talking about the gen ed population or also taking into consideration the special ed population. And they specifically gave examples that for some students that might continue to be paper packets. Distance learning does not mean online instruction. It can mean, literally, even if you're still doing it through the mail or pickup location, that's still a form of distance learning. So I just want to clarify that.
Yeah, that's definitely true.
So does that answer, Betty, does that answer your question about the word packets, or is that a different question? She says, are work packets to all gen ed students that were delivered, mailed, or picked up considered delivering?
I'll say this, again, what Chris mentioned is the CDE guidelines and the governor's guidance hasn't always been very crystal clear. It appeared what they were saying is that the preference is work towards, I don't have the exact language right in front of me, do your best to implement online delivery. However, it can be other modes of instruction. So work packets to all students, depending on the size of your district. If you simply don't have the means to deploy Chromebooks to every student, I suppose that, they'll cut them some slack, but I think the goal is online delivery if feasible. And if it's not feasible for every student, what other means are feasible where we could keep it equal access to the actual curriculum?
And I think if we're talking about the executive order doesn't speak to really delivering instruction. It talked about funding will continue to support high quality educational opportunities. So to Betty's question, would work packets be considered delivering instruction? I think it would. I don't know that we have to show technically we delivered instruction. I think what we're working towards on the executive order is it high quality educational opportunities. That's for gen ed students. And then once you're providing that, that opens the door to having to provide services to special education students. And that will, like I said, look very differently just based on what you're able to do.
And so I think that answers Kathleen's question as well about keeping track of service minutes. You just have to do the best you can. And right now is a unique time. And you know, if there's a way to do it. But if not, then you can't do it. But still try to deliver the instruction or deliver the packets when you can, right?
Yeah, I think that unless there is some model about you know how much a certain paper packet relating to instructional minutes, I would just keep what I was talking about tracking is your contacts with the student and how many minutes you're in contact. I think we can determine later if it's even necessary, you know, as far as how many minutes of instruction did you provide. I don't know that will ever be necessary, especially in general ed, because it's certainly pretty clear now that it's not necessary for apportionment. So if it's ever necessary, I'm thinking it's going to be more on the special education end when we get those compensatory education claims. On the general ed side, I think you just keep track of your contacts with the student, what you provided them, and if you're requiring them to return it. I know in my own kids' school districts, they're not requiring them to return. They're not, you know, making it clear it's not for grades. So they're just providing assignments, instructional packets, things of that nature.
Okay. I think we've answered those. Rob asked a question yesterday that he's going to ask again today, now that we have Chris on the line. He says, I'm receiving a lot of questions about HIPAA and using Zoom/Hangouts for SPED and counselors. The announced waivers of some HIPAA components have caused a lot of confusion. Is there some written guidance as to how those waivers apply in a K-12 setting, as well as recommendations for meeting settings such as enabling, disabling, recording, etc.?
And Gretchen, didn't we get, I think there have been HIPAA waivers specifically targeted towards Zoom and towards other online. I think we received that yesterday. Is that right, Gretchen?
And I just received something this morning federally talking about HIPAA waiver being either, there's been some very recent guidance that we can share with SITE as a group coming from the U.S. Department of Ed, I believe, or organizations out of DC, talking about the interaction of FERPA and HIPAA in relaxed guidelines. But I do think that the waiver specifically in express consent is something that we'll want to drill down on and follow up with this group. Whatever we have, we will be sure to forward you.
There was some question I know we received from, and I believe it was mostly from school psychologist groups, but there's typically we say in schools you're covered by FERPA. There's a which if you're covered by FERPA, you're not covered under HIPAA. But psychologists that are licensed under the Business and Professions Code, separate from their school psychologist credential, the Business and Professional Codes licensing does have a provision about teletherapy and being covered by HIPAA. And so that was a concern, but I believe yesterday's guidance / waiver, which we can get to you, I believe that it relaxed, if not waived those. But we had already talked to some clients about, we didn't think that applied in any event, because if a school psychologist is providing therapy to a student, they're providing it under their pupil personnel school psychology credential, not even if they have another MFT license under the Business and Professions Code. That's not what schools require them to have to provide the services. So we, our opinion was the prohibition on providing teletherapy unless you complied with HIPAA did not apply to school psychologists providing online therapy. But I think yesterday's guidance will probably help us even more, because sometimes it's hard to convince everyone that they're not covered by HIPAA.
I'm reading Betty's follow-up question, and the question is, if the special education student population, if they are ready to deploy online services with them, but they are not equipped yet for their general education population, can they go ahead and start delivering those services to special ed? My guess, and I want to get Chris's take on this, and the question is it equitable? My guess is that your special ed students might already receive services delivered in a different format, but also the guidance from CDE is to have flexibility and to have a program that is flexible to changing and takes into consideration the different student populations. So for that reason, I think you would have some cover if you wanted to go ahead and start your special ed students using the technology that they have. I mean, I wouldn't lag significantly behind with the general education population, but I do think that you're allowed to have some flexibility in how you roll these things out. But Chris, has your practice group already evaluated the same issue and have a different opinion?
I don't think we've talked about that specifically, but I agree with that. I would not be concerned, and honestly, I'd maybe make that even stronger. If you're ready to roll it out, I would. And I get the equity issue, but I honestly do not see a mechanism for general education students to pursue an equal access type argument, and especially if it's not a choice that we're going to provide it to special ed students and not to general ed. If you're saying you're not ready to roll that out, I think that that's reasonable, and I wouldn't delay rolling it out for students with disabilities just because you're not ready to roll it out with gen ed students.
Yeah, and I just want to, this is Andrea, reiterate what Gretchen said earlier, the guidance and the information coming from the California Governor's Office and the CDE is really gearing towards do your best. We're not going to come after you, and we're not going to punish you for what you do. I mean, obviously, like I said yesterday, you don't want to break criminal law, but if you have to bend some of the ed code and adjust what you're doing, and you have parents' consent and everybody's good to go, you're not forcing people to do something that they don't want to do, you're probably going to be okay.
Chris, can you address, I think there's been about 3 questions about IEP meetings when modifying the mode of instruction. Can you talk a little bit about that topic?
Yeah, and first of all, I think there was one even, do we still try to have, I think, annual IEPs, and then about the modification. Currently, that was one of our concerns. There is no waiver of the requirements to have the annual IEPs. I think I spoke in the beginning about the guidance we did receive from the U.S. Department of Education that was helpful, had to do with the timelines for assessment and those being delayed if they were required to be face-to-face assessments or observations. There, notably was no guidance saying you don't have to hold annual IEPs. So at this point, and again, this is still do your best, because different districts have different capabilities, but we are advising that if you can hold IEPs via Zoom. We did one the other day via Zoom, even teleconference, whatever way you can do it, and we'll argue about whether it was effective later. So I guess just to answer that, yes, we're currently still having to do that. Now, there was discussion about federal legislation that would potentially waive or toll timelines like this as well. I don't think we have that yet. So currently, if you can do it, do it. As far as modifying, my advice has been, and I think we're pretty consistent on this, is not to try to modify IEPs to reflect the different delivery model that we're using now. And the reason is really a practical, practical matter. Is you can't have amendment IEPs for every student that has an IEP in your district, or at least you can't do that quickly. And the second part of it, it implies then that now we need to get consent. It implies that this is what we think is FAPE, that this is the least restrictive environment. So there's all kinds of things that if you're trying to modify the IEP to reflect what you're doing, what we've advised instead is most districts have done it through like a prior written notice letter that due to the case closure, or the school closure, which was done in consultation with CDC and the Department of Public Health and CDE, we now have to deliver the program and services to the extent possible in an alternative method, an alternative delivery model. And so we're just doing a prior written notice that we're still delivering the FAPE that is in your IEP. We're just doing it in an alternative way to the maximum extent we can. And then that's where, in some, the case carriers kind of put together the plan, and in others, they're doing it a little more uniformly. But my concern is that, on the front end, this would be a mess trying to have amendment IEPs for every kid that has an IEP, then trying to get consent, then potentially those being subject to a due process hearing is what we just put in our IEP FAPE or not. And on the back end, it's just as problematic, because now that once you have consent and implement this alternative delivery model, and now you're providing everything in home, acknowledging it's not the best, but it's the best we can do. Once schools reopen, you're going to have amendment IEPs again to bring them back, and you're going to face the same problem. If parents don't consent, stay put will be the home environment or distance learning, whatever you're doing, and now we're going to have a mess trying to get back out of
that. Okay, next question. By the way, Betty was talking about just her special ed population, or the students that are being serviced there, in terms of waiting until everything was equal. I think the answer would be the same.
As far as
versus special, waiting until all or most of your special ed population has the ability to go online and get service, versus working with the special ed kids now who have service, knowing that not everyone has the service.
Yeah, I think, and so you're talking, so you're able to provide services to some students with disabilities, but not all of them yet?
Right.
Yeah, I would go forward in that case. I think the case that where we know we have to be careful is as soon as you provide services to the gen ed, you are required to provide them to special education. But if you're just talking about within the special education population, and the choice is, don't start services to all of them until you can, are able to provide them to every single one, I wouldn't delay I would start the services for those that you can, and just work on rolling the rest out as you can.
Okay. And then Ian is asking, we've been advised from our county SELPA that in order to provide distance learning to students, we need to amend all active IEPs to reflect modifications of services. Is that accurate?
So that is not my advice, but I know that I've seen that from district or different SELPAs. I've seen that from even some other attorneys. Again, I think so. You'll have to make your own determination, because I think Gretchen mentioned in the beginning, it's kind of the Wild West. We don't know how this will work out. In balance, my opinion was that, again, amending all IEPs as a practical matter, that's going to delay services to kids. It's going to imply that in California, you cannot start anything until parents consent. So now you're saying, parents don't consent, you're in this no man's land where we don't have an open school for them to continue to go to, and they haven't consented to our alternative delivery model. And then when they do consent, again, when schools reopen, you have to hold all amendment IEPs again, and again, get consent to get out of that placement. So that is the basis for, like I said, basis for my opinion is that it's just not practical to do that. And what we're trying to say, the argument we want to, it may not prevail, but the argument we want to make in the end is we continue to provide the program and services in the student's IEP, which is what we think is FAPE. We continue to provide that to the maximum extent possible through an alternative delivery model. That's what we did. And so if we're continuing to provide that, then the argument would be we're not amending the IEP. Now we're providing it to the maximum extent possible, and that's the language from the U.S. Department of Education is once you provide services to gen ed students, you are required to continue to provide FAPE to the students to the maximum extent possible. So that's where we want to be, I think, is to say this was the maximum extent possible. We couldn't provide all the minutes we did before. We couldn't provide all the services we did before, but we provided the FAPE in the current IEP to the maximum extent possible through an alternative delivery model. But like I said,
So
you will get different opinions on that. So I want to acknowledge that.
This is Libby. I have a quick question. So I have a child on an IEP, and I had this conversation with his counselor, his SELPA counselor, who called yesterday. And my thought, and I just wanted to kind of get clarification, and maybe this will help people. Our discussion was, since parents have to assist with those online services at home with their child with an IEP in most cases, is that enough consent? The fact that I sit there and have to help him get online, and then maybe we'll leave the room so that he can perform his services with his counselor or speech therapist, is that enough consent?
As far as consent to receiving the services online?
Yes.
Yeah.
Yeah.
Yeah, that's a good point. Because I think so. I think we've made it explicit. I had this come up in a district that is using Zoom to provide speech services and also their classroom time. And at first was doing only individual, but asked if they could do group speech, 3 kids, or a group class. And I said yes, and we just wrote it was just an email that went to the parents that said, I will be holding a group session for this, a group speech session or a group instructional session via Zoom, and which means that your child will be able to see other students and they'll be able to see him and hear him or her. And if you have any concerns with that and do not wish to, it's not mandatory, please don't enter the Zoom conference room. And I think that's sufficient because we're not mandating anything. We're making, as long as they know what they're doing and that they do not have to do it, then I think it's fine.
And just to be clear, if it's helpful for anybody, based on our discussion for my child, we are not modifying his IEP. We're kind of taking this as everybody's kind of struggling. And so in order to just get services up and off the ground and for him to not miss anything, we are not modifying his IEP. But I have consented based on helping him to do these online services. So I don't know if that's helpful for anybody else.
And did your district have a written consent, or did they? How did that get conveyed?
So right now I haven't heard anything from my district. His services through SELFA are the only ones that are continuing at this point. I think our district is still trying to figure everything out. But so that we can continue with his counseling and therapy sessions through SELFA, I just verbally consented. He sent me some resources via email, and then I felt and he felt that the consent was the fact that I was there to help him get online, because the students can't do that on their own. A parent has to help in most cases.
All right, Kathleen, I'm not sure if this was answered. Kathleen's question is regarding writing service minutes in IEPs that are being held now. Do we describe what we are able to offer under the current closure/distance situation?
Yeah, so again, and you'll get different opinions. Consistent with what I was saying before, my advice has been is to offer what you would if schools were open, and then to do the same way, to modify the delivery model through the case carrier or however your school district's doing it, prior written notice, because I think for the same consistency reasons and the same reasons that I was concerned about, if you write it in now as this distance learning home program, whatever we're doing, and that's consented to, the first thing is you'll be potentially obligated to defend that is FAPE in the least restrictive environment, and you might not think it is. So I think we want to say it was the school closure caused by a pandemic that caused us to have to do it this way, not that we decided this was the best, this was the most appropriate program and way to deliver services. And the same concern I would have is if you have now two different groups, you have one group that has the physical schools as the placement, and one that has the distance learning just because of the timing. Once schools reopen, that group that has all distance learning in as their FAPE, you're going to have to hold amendments and get consent to move out of that.
Okay. Any other questions? I know we were supposed to stop at a half an hour. It's 11:40, but we'll keep going if you want to ask more questions. And remember to unmute yourself. Kathleen, did you have a question? No. Oh.
I was thinking about our OTs and all of the physical materials that they use. It doesn't seem feasible to send sets of materials to families, but if our OTs could find a way to provide services through Zoom or another platform and suggest that parents use materials that are easily found around the home, that sounds to me like to the greatest extent possible. Would you suggest anything different?
I agree. No, I think and that's exactly what we would be saying is that That's probably for OT, working with the parent on how they can work with the child with what they have available to them, is providing that service to the maximum extent possible under the circumstances. So yeah, I think that's exactly why OT is so different from speech. Like I said, speech lends itself to online or video conferencing, and OT really does not.
Thank you.
Laurel has put in the chat a couple of things that Google made, a couple of changes that Google made to Hangouts last night, so that only meeting creators and calendar owners can mute or remove other participants, and that meeting participants cannot rejoin nickname meeting once the final participant has left. So those were a couple of things that were floating around on our online community that were concerns from members about using Hangouts. So they are listening, and they're trying to make some changes to make these tools a little more authoritative in the sense that giving the instructor more control. So.
Good.
So, excuse me, Andrea, this is Chris Jones. I have a question.
Mm-hmm.
We had one that came up, it's regarding deaf and hard of hearing. And we have some students who are deaf and hard of hearing. We also have some staff members that are deaf and hard of hearing. And we've been considering using, as distance tools just for staff members to meet and to deliver online instruction to our staff members. We've been considering using Google Meet and Zoom. But for our deaf and hard of hearing, for example, staff members, that's the first to attack. Does anybody have any suggestions for meeting their needs?
I don't know of anything as far as a technology resource. I do know that I spoke with one district who was using Zoom and an interpreter on Zoom, and I haven't checked back to see how that was working out, but that was the only DHH question I have had so far.
Google Hangouts does an automatic closed captioning. It's not amazing. It's good, but it's not great. We saw a couple words we weren't totally excited with the other day. But wondering is that considered district's best effort? Sort of going back to what you're saying, and I know there's a difference between the feds and the state coming after us and a parent coming after us. I mean, there's only so much we can control there, but utilizing closed captioning built in, is that the same thing we're looking at YouTube for like board meetings. It's all Google's technology around closed captioning, like instant.
Yeah, and I would say if that's a tool that's available, and you don't have something available and accessible that is better than that, then I think that you use that, and it's not perfect, and we're okay with that. I know the standards are pretty high for equal access to some of the supports we have in the classroom right now, but this is a different circumstance. So I hope at least we are going to have a more relaxed what's reasonable, what's possible under the circumstances, and that sounds to me like not a perfect but a pretty good option.
This is Gretchen. To provide an analogy for public school board meetings, as you all may know, that they are permitting them to be done telephonically, and the issue became, what about you members of the community who are disabled and need ADA compliant meetings? And Chris, correct me if I'm wrong, but the guidance was, upon receipt of a request for access, do what you can to provide an ADA compliant video chat, translator, interpreter, but it wasn't very strict. And so again, I think it's just that there is some give for flexibility under the circumstances.
Yeah, I agree. Yeah, I think, and maybe just to add, I think one thing that we're trying to put it in all our communication is that the first priority is following what CDC and Department of Public Health recommend and mandate as steps to prevent the spread of the coronavirus, and everything after that is do our best to do the best we can do while complying with those guidelines. And so I think we have to, every time we have to remind people that we're not choosing to provide less or something inferior. We are choosing to follow the guidance to stop the spread of the coronavirus, and then do the best we can for everything else after that.
Chris, can you talk, we talked a little bit about this yesterday, but to that point, do the best we can right now. How much of that do we need to document the decisions each district makes, in case there is a lawsuit later on, or is that not really necessary right now?
I wouldn't get it. I would do it to some extent, and we have done that. Like I said, when we feel that we're making a more significant, or our initial, I mentioned the prior written notice letter that some districts sent out initially saying we're going to provide these services in an alternative manner. I think in that kind of broad sense of the way we wanted to make it clear that we were complying with or consulting with CDC and Department of Public Health, and then we are going to deliver these services to the maximum extent possible that are in the IEP. I don't know that I would recommend, down to every granular little decision you make, say, we're doing this is the best we could do in this situation. But there certainly are, if there are broader communications going out there, or more significant ones, I think I've used the language from that U.S. Department of Education guidance that, that was in the prior written notice that I use with many districts, that we are going to provide the program and services in your child's IEP to the maximum extent possible through a different, or an alternative delivery model. So in those bigger pieces of communication, I would use it. I wouldn't worry necessarily about every email where you're making a decision to use Google Hangouts or Zoom or this or that to say that this is the best we can do. I don't think you have to document every one of those.
Thank you.
Sure. And I think, just my opinion here, but I think where you are going to, I think someone mentioned, not much you can do about parents pushing back. And I think school districts will receive a lot of leniency from, I believe, from CDE, from U.S. Department of Education, where you're not going to receive a lot of leniency or understanding is from parents' attorneys. For certain parents' attorneys, and certain parents will challenge. We already know, we've seen notice of unilateral placement due to a school closure, and seeking reimbursement. So we've already seen those challenges. So I think those are the ones I'm gearing mostly my advice towards, is thinking when the schools reopen, when the hearings go forward again, I think that's where you're going to be challenged the most, with even when we talked about for the executive order saying you need to provide high quality educational opportunities. And I think I was very concerned in the beginning, what does that mean? If, is someone going to tell us after the fact we didn't provide high quality educational opportunities and therefore we don't get funding? I think in communications subsequent to that from CDE, it seems like I just don't see them scrutinizing that all that much as far as whether you get funding or not. I kind of think they're going to give you the funding during the school closures, is my opinion on that. So that I'm a little less concerned about now than I am about what the parents are going to do when this thing is all done.
Yep. Agreed. All right. Anything else before we jump off? All right. Okay. Yeah, thank you all for joining. And again, just a disclaimer here, what you've heard from Gretchen and Chris are not formal legal opinions. It is advice, and if you have your own district legal or other legal source, you should check with them before you do anything that you think is, not the letter of the law. My opinion, I would say, we're all doing the best that we can, and you're getting the information from reliable sources. And if they ask for forgiveness instead of permission, but that's just my opinion. And hopefully you're seeing the chat. There's a lot of links going in there. Tuda just posted the link to the notes that she's taken. I did actually record this particular one. The ones previously had not been recorded, but since this was a special ed specific call, I went ahead and recorded it. So I'll see if I can get that link up on this page as well. You can get here obviously from site.org and just clicking the COVID-19 resources menu at the top. If you want to contact any of us here at site, our contact information for both board of directors and staff are also on the website for emails. So just let us know what you need and we'll try to get information for you guys. And hang in there. We're all in this together. Just keep your head up, breathe, and try to get some rest this weekend. And we'll talk to you next week.
All right, thank you.
Thanks, everyone.
Thanks.
Thank you.
Thank you so much.